tradition, before the Home Secretary, a letter is placed on the record. The letter states, and initially the letters were anonymous, given the fact that members of the House of Lords were involved, said that Lord Hoffman's wife worked with Amnesty International, in response to which the information provided was that yes, she did, but she was employed only in an administrative capacity, not involved with the decision making of and that she performed certain secretarial duties.
And they took up this application.
This application is moved to the House of Lords. While it is still pending consideration, a further letter emerges. This letter now provides, it emerges from Chile, and it provides this is not enough. Lord Hoffman himself is a director and also chairman of another charity called Amnesty International Charities Limited. That is a charity which is controlled by Amnesty International. It has no role in the filing of the intervener application.
Thank you.
It was not involved in that participatory process, but Lord Hoffman was there. And he is, of course, as a member of the superior judiciary, he could not act if it was any remunerative capacity. He was employed in non-remunerative capacity. So financial interest going back to times was...
Khatam ho gaya.
Ji.
Then was the bench reconstituted?
Yeah, how was the application taken up?
The application was taken up by a completely reconstituted bench.
Under what jurisdiction under the UK law?
My Lord, at that time, the Lord Chancellor constituted the bench. The submissions record that the Council for Pinochet submitted that you have always the jurisdiction to look at a judgment if it is infected with bias, and this
only that portion can you read?
That, yes.
Yes. Only this very portion.
Yes.
Which volume one?
My Lord, no, this is a new volume. I just placed before your Lordship. This is tab 12 of this volume.
And this jurisdiction is under what's the law that regulating the appeals and all?
My Lord, appeal is over.
No, but what is the law? I mean, they file their appeals under what law?
Common law principle.
Common law.
Common law principle. This application is moved.
Where is this portion?
My Lord,
to?
if your Lordship may turn to tab 12.
Tab
Page.
My Lord, tab 12, it opens at page 119. This is 2001 appeal cases. 119. The Lordship may see first the petition itself is mentioned at page 121.
No, we just want to see the reasoning.
My Lord, if your Lordship turns to, and then just point, okay, I will just move away from the application and take your Lordship.
Sorry to nudge you along, but we
not at all,
we
my
are
Lord.
constrained for time also.
Your Lordship will see page 125. That is the first judgment, opinion authored by Lord Brown Wilkinson. There is introduction. If your Lordship will see 126G, is it highlighted? The relevant portion is highlighted for your Lordships.
Page
126G.
Before your Lordship will see side
anyway, I just want to come to the reasoning part.
My Lord. This shows that they were made an intervener.
Yeah, that's okay.
Then your Lordship will see 127, the decision and afterwards. And the link is then pointed out, 127, if your Lordship may.
No, I just want to see the mechanism, how they overcame their earlier decision. That's what I was wanted to focus on.
And also perhaps how did they go about opening the matter?
My Lord.
I think their judgment is based on apparent bias, if you will see that page 132.
Yes, my Lord. Yes, my Lord. But if
This
your
is
Lordship
the only
may.
reason which I have seen that only the question of bias was raised there.
Yes. And that is the issue raised over here.
No, fair enough. The question is, how did they open it?
My Lord,
They say,
if your Lordship will see the decision and afterwards on page 127. And your Lordship was asking for timelines. The timelines are also here. Judgment in your Lordship's house The heading is decision and afterwards was given on 25th November. The appeal was allowed by a majority of 3 to 2 and your lordship's house.
We've understood that.
My lord.
Now attend to the application and setting aside of the order of 3-2.
My lord.
For that, how did they open the door and how did they?
Yeah, the opening of the door first, please. I mean, how did they open the door?
All right, my lord. If your lordship.
Oh, they did not even mention it.
No. That of course mention it. They point out that this is.
Why don't you come to page 132?
My lord.
It's the conclusion which talks about the jurisdiction. I think that's dealt with the issue which is there.
Apparent bias is there.
And please read the jurisdiction part.
My lord, I will.
Page 132.
If your lordship may, before that, just graciously see the reasoning of the court begins at page 125. Your lordship was asking where is the reasoning of the court. 15 January 99, Lord Brown Wilkinson.
No, it says,
that's the first.
as my lord has pointed
if
out.
If your lordship turns to jurisdiction,
yes.
That is page 132.
Let's read it.
As I have said, the respondents to the petition do not dispute that your lordships have jurisdiction in appropriate cases to rescind or vary an earlier order of this house. In my judgment, that concession was rightly made both in principle and on authority.
Where is the authority?
My lord,
where is
that,
the discussion
that
on
follows.
this?
In principle, it must be that your lordships, as the ultimate court of appeal, have power to correct any injustice caused by an earlier order of this house.
So the principle of injustice.
Injustice.
No, so where in common law is this principle?
My lord, as follows. There is no relevant statutory limitation of the jurisdiction of the house in this regard, and therefore its inherent jurisdiction remains unfettered. In Broome Castle, your lordships varied an order for costs already made to the house in circumstances where the parties had not had a fair opportunity to address argument on the point.
Another the common law.
Common law.
It's lovely.
That's the magic of the common law, my lord. It develops with time, with judges, as your lordship's approach evolves. Your lordship will see.
Khan, one thing when you're addressing, I want to be very clear on this concept as well, because we have a review jurisdiction.
My lord, yes.
Our law is fairly settled about no second reviews. So where will we draw these lines if we are exercising such a jurisdiction?
I mean, enter the Constitution.
You have to bear that in mind at each juncture.
My lord,
no, I'm just saying bear it in mind as you're making your submissions.
May I just preface it right over here, my lord, that generally your lordships have always regarded that in two respects, a decision is always available for reconsideration. One is the case of fraud, but that is now taken care of 12.2 by the statute. Yes. But the second is the case of bias. If a party is condemned unheard, or if the judge appears to suffer from a reasonable suspicion of bias, the test is as low as that, a reasonable suspicion of bias, then that can be undone. And if your lordship will see immediately after what my lord...
इसमें ये जो last paragraph है, conclusion जो draw हुआ है jurisdiction का, that is page 132.
जी.
इसको भी जरा देख लीजिएगा ना, because they have clarified.
Sorry, you were reading, I think let's finish reading this paragraph.
Brown versus Castle, your lordships varied an order for costs already made by the house in circumstances where the parties had not had a fair opportunity to address argument on the point. However, it should be made clear that the house will not reopen any appeal save in circumstances where through no fault of a party, he or she has been subjected to an unfair procedure. Where an order has been made by the house in a particular case, there can be no question of that decision being varied or rescinded by a later order made in the same case just because it is thought that the first order is wrong. So as your lordships noted earlier, there is no review jurisdiction.
Which I was asking to you read.
Yes, my lord.
This is the same paragraph.
Yes.
So the three crucial words that emerge from this paragraph are injustice, fair opportunity, unfair procedure. Am I correct? Or?
Absolutely, my lord. And if your lordship will see, it flows into the next paragraph, apparent bias. As I have said, Senator Pinochet does not allege that Lord Hoffman was in fact biased. The contention is that there was a reasonable danger or reasonable apprehension.
Well, I think that's immaterial, probably where they were just being nice. I don't know. Let's leave that aside. I'm more interested in the constitutional legal principle, whether he was biased or not biased.
My lord,
I mean, we can say the same thing here also. I mean,
Yes.
you can't look into the hearts of men.
my lord, one of the reasons
Yes.
why the superior courts all over the common law world have evolved the test, which has varied from real danger of bias to real likelihood of bias to reasonable suspicion of bias, is that it is almost impossible to prove bias.
But here, is it a question of bias, or is it a question of admission?
My lord,
Bias is that I had something against the accused appellant. That would be biased. Admission is that knowingly I decided something wrongly and I admit to it. That, would it be bias or would it be an admission?
My lord,
is it a different genre?
the latter part would be an admission of bias, but when your
No,
lord
it's not bias. It is admission of wrongdoing. It is.
wrongdoing, and when
I mean,
your
where is the bias? I have no bias, but on your saying I did something which I shouldn't have done in law. So I'm not biased against the person, but you prevailed upon me to do something.
But initially, from the portions of the transcript which were available and from what was appeared on YouTube, it appeared to be that the judge was saying that in this particular case,
Pressure tha.
is pressure tha. But when you
Where is the bias? He didn't say I hated him or I didn't like him.
but where he says that if your lordship reads his book along with his two interviews, your lordship will see that he is very clearly saying that in the case of the High Court at least, the Chief Justice who
नहीं, वो अलग बात है. हम सुप्रीम कोर्ट की बात कर रहे हैं ना. हाँ.
Supreme Court mein he says that at that time the judges were under certain pressure. He doesn't say that there was any particular pressure on him. He also mentions that the chief
But this is, I think, a slightly different category of case from bias. So
my
ये
lord-
उसमें आएगा ना भाई.
my lord, the
If देखें या तो I don't take pressure, or if it is pressure that I cannot resist, then I should disassociate myself from the bench.
correct.
I don't know.
My lord, it will fall in the category again of Pinochet. Previously the test was financial interest or interested in the outcome of the
But
case.
then we will come under injustice or unfair procedure, not bias.
My lord, reasonable if on reading the transcripts of those interviews,
But I think bias is something subjective. Unfair procedure can be categorized as something more objective. I think unfair procedure or acting under pressure of someone is on a higher pedestal as opposed to bias. Because bias, you may think I am biased, but another person may not think I'm biased. And only I know if I'm biased or not. If I do something which is objectively, I say, I decided this case, Mr. Makhloom Ali Khan, though there was no merit in his case, I decided in his favor. Okay, that is something I am doing wrong. So there is no question of bias for anybody else, but I'm either favoring you or not, or just I don't like you, I'm doing something, one of the two. So I would really put it in a different category and on a higher category.
my lord, it would, but then eventually they would all fall under the broader category which goes back.
No, but is this maybe because there's never been such a category? Maybe we need to create such a category, I don't know.
My lord, the category is created in Pinochet from the point that where they take the view that if he had
There the simple question was, because his wife, because of self, being a member, he may have been persuaded to canvass or articulate the viewpoint of Amnesty International. That may or may not be true. We don't know. Only Justice Hoffman and his wife would know that. Or the subconscious may have prevailed upon it. Let's even go that far. But nobody is saying that intentionally knowing that this order he should not have passed, he did pass. If tomorrow Justice Hoffman came out and said, I was under a lot of pressure from my wife, that whatever, if you don't decide this way, please find yourself another place to put your head down at night. I don't know. Now that would be a different category of cases. But that would be an admission of wrongdoing then.
that would be a category of admitted bias by a judge who was presiding over the trial. Because, my lord, when a judge decides on the basis of any other factor except the evidence before him and the law applicable to the case, it is said, there are categories, it is said that the judge was decided in a manner which was not proper,